If you want a good morning chuckle, you can watch this video by Cop Block Nomad. He has been listening to the likes of MarkStevens.net and Common Joe, so you know he's chronically uninformed and misinformed. He thinks the 2010 DHS memo, or the 2018 DHS memo, one of the two, I don't know which, doesn't really matter. He thinks it applies to the municipal court. This is the city of Aurora. It is the City of Aurora Municipal Court. He thinks that it applies. It doesn't. It's the interior of federal facilities. Even then, you'd still need permission. Even then, federal court orders can prohibit it. Even then, security regulations, rules, orders, or directives will apply. So you could read, well, I presume that you can read their examples, but it only applies on federal facilities. In fact, if you look, the applicability, the rules in this subpart apply to all property under the authority of the U.S. General Services Administration and all persons entering in or on such property. It does not apply to non-GSA owned property. 41 CFR 102-74 does not apply to non-GSA property. The DHS memo only applies to FPS personnel who are protecting GSA property. This is not in contention. There is no argument to support it otherwise. This is the clear letter of the law. He gets touched by a lady. She touches his camera. He wants to, I guess, go after her for assault or something like that. I wish him the best of luck. Some quick notes is that this lady right here. Quick notes, prosecutors won't prosecute for that. They just won't. Is it technically assault or battery, depending on the state law? Maybe. But are they going to assault over every time someone, or are they going to prosecute over every time someone touches somebody else? No, they're not. They're absolutely not. There are lots of things that could theoretically be prosecuted over, but if they went after stuff like this, there would just be too much. So no. And I don't even have to know if it actually does rise to the level of a crime. You could look up the jury instructions to see what all they have to prove for each element of assault and or battery in Colorado, depending on how they've defined it. But no. He's not allowed to film in there, and she is a city employee, and she is probably allowed some measure of enforcing the rules. And if that includes blocking cameras, which she's going to say I was just trying to block his camera, well, I think that she would probably be, well, she's not going to get prosecuted. I mean, let's just end it right there. There is no prosecution incoming. As far as a suit, could you technically win a tort action on assault and or battery? Sure, you could technically win. Would you get paid for it? No, there were no damages. You might get like $1 nominal damages. But since you chortle at the end of the video about how successful your video was, any good defense attorney is going to show that you actually profited from this. You weren't hurt by it, so no. Then we have tyrants. Whoop, whoop, tyrants incoming, right? No, they're not tyrants. They discuss politely with him. They try to reason with him. They try to point him to the rules. They try to get him to expedite his business. They offer to expedite his business with him to make sure that he gets to the fronts of lines to get the hell out of there so that they can restore the court to its proper order and protect due process and the fair administration of justice. And he refuses, so they criminally trespass him. There you go. Now you're trespassed. If you come back, you will be arrested for it. Congratulations. You've just earned a trespass. Now, he was already there on, what do you call it, a frivolous suit? A frivolous claim. Yeah, so he runs afoul of the law a lot. It doesn't appear that MarkStevens.net and or Common Joe are really helping him avoid being in court. So, congrats. Anything he thinks he's going to win on a 1983 lawsuit, he's not. Number one, there was no damage. And again, his chortling about a successful video would indicate that he actually profited from this and that it was his intent to get this kind of interaction. So, no damages, meaning at most, if I think it would be frivolous, I think it would be dismissed as a frivolous lawsuit. Failure to state a claim and possible sanctions for frivolous lawsuit. But even if he did win, it would be at best nominal damages, no punitive damages. He had no harm. He was not even touched. They didn't arrest him. They didn't cuff him. They didn't hurt him. It's, if this is your definition of tyrant, then you have defined tyrant down to the point where it's meaningless. Anyway, that's it for me. Thanks for watching. Have a great morning.